Okay, so, you sent us this really fascinating stuff, and we thought, you know what? Let's jump right into it.
Yeah,
We're going
absolutely.
to take a deep dive specifically into Section 314 of the Forged Act.
Sounds good.
And just so everyone's, on the same page, Section 314, that's the one that focuses on
Right.
modifications to relationship of other provisions of law to procurement of commercial products and commercial services.
It is a mouthful, right?
It is a mouthful, yeah.
But it's a really important one.
It's a really important one, and I think, we really want to get to the heart of it with this deep dive and figure out, how this recommendation is really supposed to make the DoD better at buying commercial stuff. And importantly, what are the actual steps that people can take to prepare for this?
Absolutely.
So I think, as we've mentioned before, this is all part of a series. We're going through all of these different recommendations that are in the Forged Act.
Yep.
And, Section 314 at its core seems to be about this problem that we've, heard about for a while, which is that the DoD, tends to apply all these rules and clauses that are designed for really specific and unique defense needs.
Right.
Even when they're buying stuff that you or I could go out and,
Exactly.
buy on the commercial market.
Right, exactly.
And the idea here is to try to limit that overreach or that, applying of those very specific rules to things that probably don't need it unless there's a really clear justification.
Right. Limit it to when it's legally required. We can't just,
Right.
totally do away with them in every instance. But if it's not legally required, let's take a hard look and see if it really needs to be there.
So this isn't, completely brand new, though, right?
No, not at all.
I mean, this idea of treating commercial buys differently has been around for a while.
This actually, goes all the way back to 1994 with the Federal Acquisition Streamlining Act, or as FASA.
FASA, yes.
And this was, a big deal back then. Congress said, hey, we need to make sure that commercial items are prioritized.
Right.
That we try to streamline this and make it easier to buy things that you and I can go down the street and buy.
Right.
Well, why does the D need to have such a different process for it?
Right, like buying a laptop shouldn't be as complicated as buying a fighter jet.
Exactly.
Right.
So this was a big change at the time, but I mean, it sounds like, this issue of, overregulation with commercial procurement,
Right.
that didn't just vanish overnight just because FASA came along.
Yeah, no, it sounds like it's been a persistent problem.
It has. And, over the years, we've seen reports, the GAO, the Government Accountability Office, has come out and said, hey, these defense unique clauses, they're still creeping into contracts for commercial items when they don't really need to be there.
Right.
And reportedly, this has actually deterred commercial companies from wanting to do business with a D.
Oh, yeah, I can imagine.
Yeah, I mean, think about it. The more hoops you make someone jump through to sell you something,
Right.
the less likely they are to play the game.
It makes me want to walk away.
Exactly. And so, and then later on in 2016 in the National Defense Authorization Act, there were some refinements made, trying to fix this issue again. But there were analysis done that, showed this was still a problem.
Really?
This overreach of laws that were passed after 1994
Interesting.
was still, making the process of commercial acquisitions way more complicated than it needed to be.
So, it's almost like, we're using these, really specialized tools for a job that could be done with much, simpler tools.
Absolutely. It's like using a surgical laser to cut open a box.
Right.
When, a pair of scissors would do the job just fine.
Yeah, exactly.
And it's not just, GAO pointing this out.
Right.
We've also seen studies from the Defense Science Board and efforts coming out of, innovation.defense.gov that have really pushed for the DoD to start aligning its purchasing practices with, the way the commercial world does things.
Right.
This isn't about, cutting corners or reducing oversight. This is about just, applying the right level of regulation based on what you're buying.
Right. Applying the right tool for the job.
Exactly the right tool for the job.
Okay. So all this, brings us up to speed to Section 314 of Senate Bill 5618.
Yep.
What are the key details here? I mean, what should our listeners know?
So 314 was introduced on December 19th, 2024
Okay.
by Senator Roger Wicker. And I think what's, interesting here is that it's kind of like the culmination
Right.
of decades of trying to address this issue.
Right.
It's not like a sudden radical shift. It's really the next logical step
Right.
in a long road to try to reform defense acquisition.
Right.
And it's building on that history that we've been talking about, with FASA and the 2016 NDAA.
So it's evolutionary, not revolutionary.
That's right,
Yeah. So what are the intended outcomes of this recommendation? I mean,
Right.
what are we hoping to see change in the way that Dodd, actually buys commercial stuff?
Yeah, so there's 5 main desired effects.
Okay.
They're laid out in this recommendation. So first, the primary goal here is to limit those defense-unique provisions to only the ones that are legally required. Make it simple, reduce the burden on everybody involved.
Makes sense.
And then second is to require a justification anytime you want to include a defense-specific clause that was introduced after 1994.
Oh, interesting. So newer clauses.
Newer clauses, yeah.
They need extra justification.
Yeah, you got to really make the case.
Right.
Why is this so important that we need to include it on this commercial item purchase?
Yeah, that makes sense.
Because maybe we already had FASA, so anything after that was already supposed to be, tailored.
Right.
So let's be extra careful about those.
Yeah, so if it's a new rule, from the last few decades, there should be a strong case for applying it to something that's already commercially available.
Exactly.
Okay, so that's 2. What else is on the list?
So the third one, this one's interesting, is to extend these streamlined rules to subcontracts as well.
Okay, so not just the prime contractors.
Not just the prime. Yeah, so think about, if you're a small business
Right.
and you're selling, software, let's say.
Right.
And you're working with a larger prime contractor on a DoD contract.
Okay.
Well, now, you're not directly dealing with the DoD, but you're still subject to some of these rules.
Right.
So this is trying to make it easier, even those commercial suppliers.
Right, so broaden the pool.
Broaden the pool, exactly.
Thin it up.
So number 4 is about, those COTS items, those commercially off-the-shelf items.
Right, so stuff you can just buy off the shelf.
Exactly, yeah.
Go down to Best Buy and pick it up.
Like you said, your laptop, your monitor, those kind of things.
Right.
They want to really tailor those rules to just be standard commercial practices.
Right. If I can go buy it at Best Buy, why do you need a whole different set of rules?
Exactly. And then lastly, the tough one is to just enhance the DoD's flexibility overall.
Okay.
So that they can get access to, these new technologies, these innovations faster.
Right. Well, I mean, we've talked about that before, right? How commercial technology moves so much faster than, the traditional defense acquisition process.
Think about AI cybersecurity.
Right.
All these areas where, the commercial world is just moving so quickly.
Right.
And the DoD needs to be able to keep up.
Right.
So if they can streamline these commercial procurements,
right,
they could adopt these technologies so much faster.
Yeah, potentially, months or even years faster.
That could give them a huge advantage.
Yeah, and in a world where technology is, kind of the deciding factor so often, that could be a really big deal.
Oh, absolutely, yeah.
Okay, so those all sound like really, positive potential outcomes. But, I mean, let's be real. Anytime you make a big change like this, there are going to be challenges.
Of course.
What are some of the potential downsides that people have, pointed to?
So there's a few things that we need to think of.
Okay.
One, valid concern is that by, stripping away some of these clauses,
right,
we might weaken the oversight and create some gaps in compliance.
Right. So if we're not careful, it could backfire.
It could. And, another concern is that this process of justifying the inclusion of those post-1994 clauses
right,
could become really bureaucratic.
Oh, interesting. So the fix itself could cause problems.
It could, yeah. And it could actually slow down, procurements.
Right.
Especially urgent ones if it's not implemented effectively.
Wow. So it's almost like we're trying to speed things up,
right,
but we might actually slow them down if the cure is worse than the disease.
Exactly. If we create this whole new bureaucratic process
right,
to justify why we need a certain clause that could defeat the whole purpose.
Yeah. So what else, what other potential, negative impacts are there?
Well, we also need to think about the, those traditional defense contractors.
Okay.
Right. They're the ones who are used to, this really heavily regulated environment.
Right.
And this shift towards commercial items and streamlined rules,
right,
it could actually put them at a disadvantage.
It could, yeah, and it could make it harder for them to compete.
Absolutely. And then, another concern is that if we just, blanket excludes all those post-1994 laws,
right,
we might accidentally lose some important safeguards.
Oh, interesting.
That were put in place for a good reason.
Yeah.
And that could create new vulnerabilities in the supply chain.
Right, because some of those rules might actually be really important.
They might be, yeah. And then lastly, if we're not careful and these determinations about which clauses are actually necessary, if those are made inconsistently
right,
across different parts of the DOD,
okay,
that could create a lot of confusion for vendors.
Right.
And it could disrupt the supply chain.
Yeah, because then vendors would never know what to expect.
They'd be like, well, when I'm working with this part of the DOD,
Right.
these rules apply, but when I'm working with
Right.
this other part,
Right.
it's a whole different ballgame.
Yeah, that's not a good situation.
Yeah, it would be a mess.
So it really highlights, this need to balance
Right.
streamlining and, still maintaining oversight.
Absolutely.
So what are some of the ways that the DIOD could try to mitigate these potential negative impacts?
Right. So there are some, suggested mitigations
Okay.
for addressing these concerns.
Right. Let's hear them.
So first, to address that risk of weakened oversight,
Right.
one idea is to conduct regular compliance audits.
Okay. Yeah, that makes sense.
Right, so that we're actually checking and making sure people are following the rules.
Right. So we're streamlining, but we're not just, throwing the rules out the window.
Exactly. We're still keeping an eye on things.
Okay. What about the, potential bottleneck with that justification process?
Yeah, so to prevent that from, slowing things down, the idea is to streamline that process.
Okay.
Have, predefined criteria for what justifies using a certain clause.
Okay.
And, clear timelines so that it doesn't drag on forever.
So it's not just, a black box
Exactly.
where things get lost.
And then, to make sure those traditional contractors aren't left behind.
Yeah.
One idea is to offer, parallel contracting opportunities that are more tailored to, their expertise.
Okay. So they still have a place.
Yeah, absolutely.
Even in this new world.
Exactly. And then, for those concerned about losing critical safeguards,
Right.
the key here is to retain the flexibility to apply those safeguards on a case-by-case basis.
Okay.
Where it's really necessary.
But we're not throwing the baby out with the bathwater.
Exactly.
Okay.
And then lastly, to avoid those inconsistent determinations about, which clauses are actually needed.
Right.
The idea is to publish clear and, comprehensive guidance.
Right. So everyone's on the same page.
Yeah, a clear playbook so that everybody knows, how this is supposed to work.
Right. This is how you play the game now.
Exactly.
So who in the DOD is really going to, be most affected by this change?
Yeah, that's a great question. So
who are the people who are going to really feel this?
So the Undersecretary of Defense for Acquisition and Sustainment,
Okay.
They're definitely going to have a bigger role.
Okay.
Because they're the ones who are going to be responsible for making those written determinations about, when a defense unique clause really needs to be used.
Right. So more power to them.
Yeah, more power, more responsibility.
Okay. What about, the folks on the ground, the contracting officers?
The contracting officers are going to be, significantly affected as well.
Yeah, I can imagine.
They're going to have to adapt to these, superfied rules, and they're going to need training and new skills.
Right. They need to learn the new playbook.
Exactly. And then, of course, the whole procurement staff in general,
right.
They're going to be the ones who are dealing with the DFARS.
Right, the DFARS.
The Defense Federal Acquisition Regulation Supplement.
The rule book.
The rule book, exactly. So they're going to have to manage these revised lists of clauses.
Okay, so big changes for them.
Yeah, big changes. And yeah, their focus is going to shift more towards, monitoring compliance.
Right, making sure that everyone is following these new rules.
Exactly.
So, it's not just a policy change.
Yeah.
It really is going to require, a lot of training.
It is.
And adaptation across the acquisition workforce.
Absolutely.
So, I'm curious, who do you think is going to push back against these changes?
Yeah, so there are a few groups that we can probably expect some resistance from.
Okay.
First of all, those traditional defense contractors.
Right.
They might, they've built their businesses around this complex regulatory framework.
Right.
And they might be worried that these changes are going to, kind of level the playing field.
Yeah, I can see that.
And make it harder for them to compete.
Okay.
And then, the DOD's own legal and audit teams.
Right.
They might raise concerns about, reduced oversight.
Yeah.
And, the potential for increased noncompliance.
Right. So they're going to want to make sure that, we're not opening the door to fraud and waste.
Exactly. And then, Congress is always going to have a role here, too.
Right.
Congressional overseers might, push back if they're worried that this is going to bypass important laws that are passed since 1994.
Right.
And, they're going to want to make it that those safeguards are still in place.
Right. So, understanding that potential opposition is going to be really key.
It is, yeah.
To making this implementation successful.
Absolutely.
So what kind of additional resources are going to be needed, to make this happen effectively?
So we're going to need a few things. First of all, we're going to need funding.
Okay.
To update the DFARS.
Right, the rule book.
The rule book has to be updated.
Yeah.
To reflect these new rules and procedures.
Okay.
We're also going to need, training programs for the acquisition workforce.
Right, so that everybody knows how to play by the new rules.
Exactly. And then, we might need additional personnel
okay.
to support, making those determinations about which clauses are necessary.
Right, so more people to actually do the work.
More people, more resources.
Yeah.
And then, we need to have a way to track whether this is actually working.
Right. I mean, how will we know if Section 314 is actually achieving its goals?
Yeah, so there are some suggested measures of success.
Okay, what are those?
First, we want to see, a reduction in procurement times.
Okay, so things are moving faster.
Faster, yeah. The goal is to achieve like a 15%, reduction.
So we're not talking about, small incremental changes.
No, we want to see a real improvement. And then we want to see, growth in commercial contract awards.
Right, because that would indicate that, more commercial vendors are actually, willing to work with the DoD.
Exactly. They see it as a good opportunity.
Yeah.
And then lastly, we want to maintain high compliance rates.
Right.
Like 95% or better.
So making sure that streamlining isn't leading to more fraud and waste.
Exactly. We want to be efficient, but we don't want to, sacrifice accountability.
Right. So those are some pretty clear benchmarks.
Yeah, they are.
But you know what? If this approach, doesn't quite pan out the way we hope.
Right.
Are there other, alternative approaches that could be considered?
There are a couple of other ideas, floating around.
Okay.
One is to use, those selective clause waivers.
Right.
More extensively. So instead of, having this big statutory change,
right.
we could just say, for this particular type of commercial item, we can waive these specific clauses.
Okay.
And that would give us more, flexibility.
Right.
We could tailor it to, the specific situation.
Right.
And then another idea, and this kind of aligns with some of the innovation efforts that we've seen from places like innovation.defenda.com is to develop a, digital compliance tool.
Okay.
And, that could potentially streamline the compliance process without having to make, big statutory changes.
Okay. So almost like a smart system that helps contracting officers figure out, which rules apply.
Exactly.
Okay. So, those are some interesting alternatives, either a more targeted, flexible approach with waivers or, leveraging technology to kind of streamline compliance.
Yeah, it's about finding that balance between efficiency oversight and making it, easier for these companies to work with the DoD.
So to sum it all up, it sounds like Section 314 of the Forged Act is really, potentially a huge step.
It is.
Towards making it easier for the DoD to buy commercial products and services. And the ultimate goal here is to, be more efficient and get access to all that innovation that's happening out in the commercial world.
Absolutely.
But as we've discussed, making this a reality is going to require careful implementation.
It is.
It's going to require oversight. Training, and really thoughtfully addressing the concerns of all the stakeholders involved.
Absolutely.
So it's a complex undertaking, but, the potential rewards for both the DoD and the commercial sector are significant.
They are, yeah.
So, thinking about all these potential shifts, it really makes you wonder, what new skills, what new perspectives are going to be most valuable for people who are working in, DoD commercial procurement.
Absolutely.
Because it feels like these changes are going to open up a lot of new opportunities.
They are.
But they're also going to require a lot of adaptation, the way that people approach their jobs.
Absolutely.
So definitely something for you to consider as you, prepare for these potential changes. So thank you so much for taking this deep dive with us.
My pleasure.
And we'll see you next time.
Sounds good.